Good evening and welcome back to the second session of the business law that I am addressing you all in the syllabus. Now yesterday we discussed about companies in general and how the companies function in domestic as well as international level, as well as the incorporation, and then we also discussed about the shareholders. So let me continue from there onwards in today's lecture, where I would like to mainly focus on the two main important persons involved in the company's operation. On one hand, we have the shareholders, about whom I discussed yesterday, how to become a shareholder, what are the liabilities of a shareholder, and the other area that I would like to concentrate is on the directors, the other type of persons involved in this company's management and conduct. Now, before I go to the discussion about the directors, when we talk about the shareholders as well as directors, we know that the shareholders who create a company and subscribe to its shares become the virtual owners of a company. But at the same time, I mentioned to you all that the company has a distinct personality separate from these shareholders who are really inside the company. So with that, I would like to talk about the doctrine of ultra vires, which means that either shareholders or directors work outside the scope within which they have to act in a company, become responsible and liable for such acts of ultra vires. In that, I would like to explain first of all with a very landmark case called the Ashbury Railway Carriage and Iron Company versus Rich. Now in this case, yesterday I briefly discussed about how this act of ultra vires can cause in an article of association as well as of the conduct of its shareholders and directors. Now if you take the member articles, for example, yesterday I mentioned that the company law in Sri Lanka require the submission of articles of association at the time of incorporation, which is in fact a mandatory method or mandatory means. When you are submitting the articles of association, there are two ways that you can follow. One way is that you make your own articles of association, and the other way is that you rely upon the articles that have been provided in general in the Companies Act as the schedule, which means that you do not have to recreate anything. You can take use of the articles that have been provided in the schedule. Whatever way, when you make the objects of or the purpose of the company being very specified to certain activities, you need to function the company within such borders. But if you make the purposes and objectives quite general, that would mean that you can do anything in the company as long as those acts fall within the generality of the purpose and objects for which the company has been incorporated. The danger in specifying the objects is due to the fact that, as I told you, this could amount to acts of ultra vires in case if the company shareholders or directors take the decision of diversifying into different areas that are not listed as objects in the company articles. In the Ashbury Railway Company, railway carriage also, it was the same situation where this particular company took the decision to operate in some areas of business that were not listed in their objectives. And the court held that that itself amount to acts of ultra vires, and whatever the agreement that the company makes with a third party in that case would be void or would be invalid. And therefore, the company ultimately become responsible. Now, when the company ultimately become responsible, it gives the opportunity for the court to lift the corporate veil. The corporate veil, which I would like to address you later after going through the director's role in the companies. Now, by the fact that I mentioned that you got to be acting in accordance with the objects of the company, it does not mean that you should always spell out your objects in much more general scope or general term. It depends on the circumstance. It depends on the circumstance what the company would like to do. Certain companies in its creation don't want to do all and sundry. They want to focus mainly on one or few business areas. So they restrict the scope to those areas. There the advantage is that the shareholders and the directors cannot work in an environment that would allow them to do all kinds of activities that have some kind of control on the directors in particular. Therefore, specifying the objects of a company would be quite beneficial for the company to exist as well, rather than being general in your objects. Now, coming to the role of the directors, I would like to address you all. Now, who are these directors, first of all? When a company is formed or incorporated, I told you yesterday that you need to submit your application for incorporation along with the articles of association, and also the particular application requires you to fill up the names of the directors. It is because of the fact that the company's management and conduct are done by the directors in particular. The directors are the ones who would be directly involved in the operation of the company. The shareholders take decision at their own shareholders meetings or at the annual general meeting or at any extraordinary general meeting. But the general functioning of the company depends on how good your board of directors are. So having a very strong and competent, skillful board is very important for any company. Shareholders may be those who have some means of finance to start and operate a company and make it financially viable. But some cases they may not be skillful or talented to operate the business that the company is doing. And that's the reason why mainly you need directors to run the show using their skills and capabilities. So at the very inception, it is important that you have the directors of the company whose names and details have to be given to the Register of Companies along with the forms. And then if you firstly provide the list of directors, these directors becomes the first directors of the company, and thereafter you can keep on changing based on the law on how to remove and how to include and how to dispel the directors. So therefore, the role of the directors is quite imperative for a company, as well as it is indeed necessary for a company to have the named directors functioning in the company. Now, what are the eligibilities of a director? Who can become a director of a company? The company's law has defined certain categories of persons who are eligible to become directors of a company. They include anyone who has attained the age of 18 years. That is because of the fact we know that the Age of Majority Act in Sri Lanka, the Age of Majority law requires, or rather make provision that an adult is a person who has attained an age of 18 years in this country. Also, this age of becoming an adult may vary from country to country, but in our country it is 18 years. And anyone who is less than 18 years is called a minor. And a minor is an incapacitated person before the law, in the sense that a minor cannot contract. So when a minor cannot contract, the company directorship cannot be given to a minor as well. So that's why the age of majority of 18 years is of paramount importance for anyone to become a director of a company. So the next one, eligibility, is that anyone who is not declared as an insolvent. That is to mean that a director must have a good sound mind, who is not insolvent, who is not having an insanity. And also here, when you talk about an insolvent, we know that it's a matter of fact that has to be proved as a matter of law. So anyone who may have an uncovered insanity would not be barred from becoming a director. But if the law has pronounced a certain person as having an insanity or insolvent, in the sense a bankrupt person, a judged person, a person who has been judged by the court or issued a certificate of bankruptcy against this person, they may not be able to be a competent person to hold office as a director. So both insolvency as well as insanity would make a person unqualified to become a director. Then anyone who was prohibited to act as a director under the former law in this country, which is the Act number 17 of 1982. In the operation of this particular law, the former law, if there is any judgment against a director that he is not capable of acting as a director in a company, would make him prohibit, even under the present circumstance, to become a director of a company. And then anyone who is prohibited to act as director or promoter by virtue of the operation of section 213, 214 of the former law are also ineligible to become a director. Now here, since the term promoter was mentioned, I would like to make a clarification as to who is a promoter. Promoter is a person who does all matters connected with a formation of a company, who would like to constitute a company and apply for incorporation and do all other incidental matters such as entering into pre-incorporation contracts, for example, and promoting the company's prospectus and articles prior to registration, and canvass for business and other matters related to the formation of the company. These promoters thereafter may become either shareholders or directors, and therefore they are as important as the shareholders and directors when the company comes into operation upon incorporation. So whatever the contracts they make, the pre-incorporation contracts, have an effect on the future company, because our law specifically says that pre-incorporation contracts are valid even beyond the incorporation of a company, which is a slight deviation from the common law situation. But of course, our law has agreed to that the pre-incorporation contracts are valid. And then the next category of those who are eligible are the ones who are, like I mentioned, the unsound mind, yes, insanity, having insanity, but then a person that is not a natural person, which means that a company cannot become a director of another company. Say for example, if you need to appoint XYZ Company Private Limited as a director of ABC Company Limited, it is not possible. For XYZ Company Private Limited to own shares of ABC Company Private Limited is possible. But representing the board of ABC Private Limited by this company XYZ Private Limited is not possible. But however, directors or appointed persons of the XYZ Company Private Limited are in fact eligible to be directors of ABC Company Private Limited. That is because all directors of a company need to be natural people, not corporates. They all have to be natural people, like I mentioned to you yesterday. Who are these natural people? Anyone who is not qualified under the articles of the company are not eligible to become directors. Sometimes the articles of the company might say that certain categories of people or certain shareholders of the company are not eligible to become directors of that particular company. In that case, those persons are not qualified to become directors of the company, if the article says so. Then, anyone who has been convicted of an offence punishable by imprisonment under the present Companies Act. Now, this we have to be very careful here. Those who have committed an offence punishable by imprisonment and they are found to have committed the crime or offence rather, would not be eligible to become a company director. Now, this is a reservation that such a disqualification lapse after 5 years of the term of imprisonment and enable such a person to become director thereafter. But however, we need to understand that it is not with regard to any offence punishable by imprisonment, but only with regard to the violation of the company's law, where a certain person has committed an offence within the operation of this company's law, who is not eligible to become a director likewise. And anyone who has been convicted of an offence involving dishonest or fraudulent act. Anyone who has committed an offence of dishonest or fraudulent act. And that also has a reservation that the disqualifying period would be 5 years, after which he may be able to become a director of a company. Now, these are the eligibilities or non-eligibilities to become a director in a company. According to our law, the company's law, the number of directors that a company can have are specifically mentioned. If it is a public company, a single director, 2 directors need to be there, at least, and the maximum would be 50. But however, in a private company, even 1 director is enough for the existence of the company, what we call a single director situation. Now, this is different from the old act, where the old act required 2 directors at least, but now the present act has accommodated the inclusion of a single director company under the law. How can a director be disqualified from acting as a director? What are the instances where a director becomes disqualified to continue? If the director is convicted of an offence punishable by imprisonment under the Companies Act, he may not be able to continue as a director. Also, if such a director has been convicted of an offence involving in a dishonest or fraudulent act, will not be able to continue as a director. And when it goes to, and when both these situations go back to the eligibility criteria, in the eligibility they say until the lapse of 5 years they are not qualified. But here we are discussing about a disqualification of an existing director to continue in office. Then if the particular director has been adjudged insolvent, bankrupt, then when a certificate of insolvency has been issued against such a director, he may not be able to remain as a director of a company. Now, we have seen some good examples in this country, especially in the financial sector, how certain directors of certain companies, reputed companies sometimes, had committed these offences, and now they have been disqualified to remain in those posts. Then anyone who is any director adjudged to be of unsound mind. Now, adjudged is a very important area in both these situations of insolvency as well as of unsound mind, the insanity factor. As I mentioned to you before, there shall be an order of the court or certificate of insolvency or a pronouncement of insanity against that person. Then such a director is not in a position to continue as a director. If the director has been prohibited by code of law to be a director, the next situation, he has been specifically ousted by the court from being a director. Then if the director has persistently failed to comply with the provisions of the Companies Act, then he is not qualified or could remain in the director's post any longer. Then if the director has been convicted of an offence involving dishonest or fraudulent act abroad. Now, this is different from the earlier factor I mentioned. Earlier it said convicted of an offence involving dishonest or fraudulent act as per the company's law. But also, if the particular director has been convicted of an offence involving dishonest or fraudulent act abroad, then would be prone to a disqualification to act as a director. Then a director being responsible as a director of a company that was declared as insolvent, which means that that particular director was instrumental in making the insolvent company insolvent, or that that particular director's act or omission resulted in that former company being insolvent, bankrupt. Then in that case, the director is disqualified to act as a director, or a person is disqualified to act as a director. Now, let me focus on the duties and responsibilities of directors. Before I go into much detail, I would like to mention to you, as I said earlier, directors are the ones who are running the day-to-day show in a company. So, they do the operation, not the shareholders. Therefore, the directors have a much more duties and responsibilities as far as the company is concerned. The directors are real agents of a company, agents of the company, that the directors have to take care of the company affairs. Therefore, they have their respective duties and responsibilities in continuing their office as directors. Under section 187 of the company's law says that act in good faith, directors shall act in good faith and for the best interest of the company. Now, here what is important is that acting in good faith towards the functionaries of the company within the framework of the articles of association, and also to operate the affairs of the company for the best interest of the company. That is to execute everything that is required under the articles of association for the best interest of the company. Because the articles of association is the constitution of the company, as I mentioned to you yesterday, and therefore you need to operate within this constitutional framework of the company. And under Article 188, the directors shall not act in a manner contravenes with any provisions of the Companies Act. Now, this is quite a large scope, that obviously one may tend to think that a director has to know every such provision in the company's law. Yes, it is, because it is very specifically says that shall not act in a manner contravenes with any provision of the Companies Act. Thereby, a director need to be guided by the company law in this country in executing his or her duties as a director of a specific company. Under under section 189, it states that the director shall maintain the standards of care. Standards of care. Now, let me pause there. Standard of care in the sense that the director must act with due diligence, proper due diligence, with the foresight, with the necessary skills, and with everything that he got to have to execute his duties in a manner that fulfills the criteria of the best care that the director could give towards the company. Now, maintain the standard of care by not acting recklessly. He should not act in a reckless manner or gross negligently. Now, negligence in the sense have three main elements: the duty of care, the duty not to breach that care, and also third one is not let any resultant damage occur by your act. So, in that case, a director shall not engage in any act of gross negligence, and also he is deemed to apply the skills and care expected out of a person of his knowledge and experience. Now, that gives some relief where the director is not expected to apply a very sophisticated expert knowledge in the company, but the maximum standard of care that he has to take within his kind of ability and competence. And that is why it says finally, a person, it should be in relative to a person of his knowledge and experience. So, we know anyone can become a director as long as they fulfill the eligibility criteria. there is no educational or professional qualifications needed unless the articles bring in certain thing as a qualification criteria. But however, anyone can act as a director as long as he applies the standard of care that is required by his level of knowledge and competence, which means that he should not act in any manner that is lower than his knowledge and experience and so forth. Also, section 190 says that the director should use information and advice provided by an employee or professional advisor or expert or any other director or committee of directors. He should use information and advice that are given by the employees of the company or any experts or professionals who have been assigned to do such a exercise, as well as the board collectively, because it is general perception that the directors of a company are collectively responsible. They cannot pass the ball to another. Whatever the decisions that they take in the board, they all are collectively responsible, unless a certain reservation or objection is placed on record at the board meeting. Then section 192, the directors should disclose any personal interest on company transaction. Now, we hear a lot about insider trading, right? So, in such a case, if a particular director has any interest in the company transaction, they should disclose that to the board. Now, this is a very important area, because even I told you a shareholder can become a director, there is no problem. And a shareholder is a person who has the direct interest of the company. But in case a shareholder becomes a director, it is a double role that that particular person is executing. Role as a shareholder, role as a director. But as long as he is executing the role as a director, he is deemed to disclose any personal interest on the company transactions to the board of directors. And then under section 197, the director shall not disclose any information to which only that director has access in his capacity or being an employee. We know that some directors are working in a company. Some directors may not. The directors who are working in a company have access to the day-to-day operation and the information. So, as long as he is acting as a director or an employee of the company, he shall not disclose information to which only that director has, which is quite private, but in the company's interest. It is not about his personal life, but any information in the company's interest that this particular director has with him, he should not disclose to an outsider. And also section 200 says that a director shall disclose any share dealing having interest in shares of the company. If he participates in any share dealing as a shareholder perhaps, then in his double role as the director, he needs to disclose that to the board of directors, because he is not only a shareholder, but he is also a director of the company. So, these are mainly the duties and responsibilities of directors specifically addressed in our company's law. Now let us look at the consequences of wrongful act of shareholders and directors in a company. Now they are the most important people in a company, the shareholders and directors. So their acts and omissions do affect the company affairs and the company's existence, as well as their wrongful acts would be to the detriment of the company itself. Therefore, it is very important for us to discuss about this area, since these wrongful acts would not only cause threat to the company, but also to the third parties who are dealing with the company. And then what amounts to a wrongful act or omission of a shareholder or a director? The effects of a wrongful decision or act or omission, including acts of ultra vires, amount to the lifting of the corporate veil to determine those who are responsible for such conduct. The company does not hold any liability in that respect. Now here I would like to explain to you about the acts of ultra vires. Yesterday I mentioned to you, which forms acting outside the scope, acting in lack of authority, acting in excess of authority, acting in abuse of authority. If the shareholders or directors commit either of these things, it is said they are said to be acting in ultra vires. Now, who sets these boundaries or the limits in a company? It's the Articles of Association, the constitution of the company again, that sets these boundaries. So the directors as well as shareholders are bound to act within these boundaries or the scope for which the company has been created, that are much more specifically spelled out in detail in the Articles of Association. As we saw in the Ashbury railway carriage case, acting in ultra vires would amount to the particular act being pronounced void and have no effect, or what we call the null and void situation, where the company would not be responsible for such acts that are being committed by the shareholders and directors of the company. So the company, being a distinct and separate person, can keep away and let the directors and shareholders become personally liable. Now that is the same instance where the court would lift the corporate veil to find out who are really behind these wrongful acts. If the company is innocent, if the company has not done anything wrong, but the shareholders or directors or both, then the court would lift the corporate veil to see who are inside this company and who are running the show. Now lifting of the corporate veil is also called the piercing of the corporate veil. It's the same thing, piercing or lifting of the corporate veil. The landmark case that brought into being this particular concept is this case of Guildford Motor Company Limited versus Horn. What happened in this case is that Mr. Horn was employed as the managing director of Guilford Motor Company that produced Guilford vehicles. His contract of employment in the company specifically mentioned that upon his resignation or retirement from the company, he shall not solicit the customers of Guilford Motor Company. This is a very common scenario even at present, that the companies make such clause in the contract of employment when they give employment to people. Here what happened was, Mr. Horn resigned from the company and left his employment, but he opened his own business of doing the same kind of business, business that his former employer was doing, Guilford and Motor Company was doing. Now, one may ask me, out of this content of the subject, that can't an employee go to a competitor of his or her former company and engage in the same kind of employment in that new company? This is a common issue, because I know nowadays the employers take a letter as a part of the contract of employment that the employee cannot work for at least till a lapse of 3 years, cannot work in a competitor company or can't start the same business. The answer to that question is that simply it is possible for anyone to go and work in a competitor company or start his own business in that same line. The only thing is that you cannot take away the customers as well as the intellectual properties of the company and operate in the new company or in the new business. Why I say is that, now look at a situation where, for example, a software engineer who is employed in an IT company and develops certain software, and if he resigns that company and goes into another place, is he meant to serve tea there? No. His expertise is in the building of software. But however, if this person uses a kind of a source code of the former employer, that is a situation where he breaches that commitment that he has given to the former company, the former employer. That is what he cannot do. But a software engineer going from one IT company and to another IT company and doing the same thing is quite possible, because that is his means of earning. What can he do else? He can't be staying at home for a period of 3 years till that particular condition lapses. No, simply he can be employed with a competitor, he can start his own business in the same line, but he cannot compete in the same type of area that he was servicing for his former company. Now, that is what happened in this case, Guilford Motor Company versus Horn, where Horn went and built the same kind of technology in his own business. And after some time, he realized whether he is really breaching the term that he signed for his former employer, that he would not solicit his the former company's customers and so forth, because it is those customers used to come to Horn's business as well, those who had these Guilford cars, Guilford vehicles. So he took advice of a lawyer, and the lawyer says not to continue in the same manner, but he could make a company in somebody else's name and operate the business. So he made another company called HM Horn and Company Limited, giving shares to his wife and another person called Howard, and operating this company. But he made a huge mistake, because he mentioned in his marketing materials to promote the business that he is giving the same service and spares as the Guilford Motor Company. It is actually Horn and Company did the marketing, that they are giving, the company is giving the same spares and services as the Guilford Company. It is not Horn. But however, the Guilford and Company went to courts against this Horn and Company for anti-competition. The court then had a look at the company, Horn and Company, but they found that the shareholders are Mrs. Horn and Howard. There was no name of Mr. Horn, who was former employee, who had also given the undertaking that he would not solicit the customers of the Guilford Motor Company. Now, the court came into a juncture that they could not realize who is doing this. So what the court did was, without relying upon the company incorporation name HM Horn and Company, lifted the veil to see who is really behind this, who is really acting here. And then they found that it was this Horn purportedly creating this company in breach of his commitment and running and soliciting the customers of the Guilford Motor Company. And the court came to the decision that in such a case, the court has the right to lift the corporate veil to see who are really acting inside the company, and say that the company, Mr. Horn, is liable, or rather the company is liable, because it is run by inside Mr. Horn after piercing the corporate veil. Now, similar situations happen in this National Bank versus Jayawardena case, where the facts are different, but in this case also our courts lifted the corporate veil to find out who are behind a particular company. It was pronounced that although the independent personality of the company, which means the company, is distinct from its directors and shareholders, in appropriate circumstances, court have lifted the veil of incorporation to find who are really behind this. In particular, courts have been vigilant not to allow the veil of incorporation to be used for some illegal or improper purpose or as a device to defraud the creditors. But when there is suspicion that certain illegal elements are operating inside the company in a way that the company as a distinct person getting affected by such acts, such wrongful acts, then what the court does is lifting or piercing the veil and see who are really behind this, and then put the responsibility, liability upon these individuals. So the liability does not level against the company, but against the individuals who are acting in such wrongful manner, and liability becomes personal on them. The next area that I would like to talk about, the mishandling of company affairs, either by shareholders or by directors. So in that respect, there are two main types of matters that we could take up. First being the operation and mismanagement of a company. Now, with the main idea that a company is a distinct person, artificial and juridical, but however the company affairs are run by natural persons, makes it quite unfair on the part of the juridical person, the company, if these natural persons are not doing their functions as required by the law. One such area is where the management of a company is responsible for oppression or mismanagement. Now, these are two different areas, of course, though our company law has addressed them together. Even in the former law it was there. Now, under section 224, it mentions what is oppression. Oppression is where the affairs of a company are being conducted in a manner oppressive to any shareholders. Directors acting in a manner with regard to the affairs of the company and conduct these things that are oppressive to the real owners of the company, shareholders. Now, what is oppressive is not mentioned in the company's law, but if you apply the general definitions, it means that anything that is burdensome or unjustly harsh or tyrannical or causing discomfort by being excessive, intense, distressing or grievous, and etc. So, it is very difficult to draw a line where the directors cause oppression, even by way of a simple act, oppression may cause. But however, how simple the act could be, that it should be quite burdensome and unjustly harsh towards the company's shareholders, and obviously acting in contravention with the Articles of Association. In a situation where the directors act in such a manner, the shareholders have the right to take action, not only with regard to oppression, but also to mismanagement of company affairs. In a case of a mismanagement, what leads to that is mentioned in section 225. That says that the affairs of the company are being conducted in a manner, if the affairs of the company are being conducted in a manner prejudicial to the interest of the company, or material change has taken place in the management or control of the company, whether by alteration in its board of directors, agents, secretaries, or in the constitution or control of the firm, or in the ownership of shares, and due to that it is likely that the affairs of the company may be conducted in a manner prejudicial to the interest of the company. In all these circumstances, it amounts to mismanagement by the directors. Now, this is very, very large in scope, as you see, and if you read at section 225, you would find out that it covers a huge spectrum of acts of detriment that are being caused by the directors. And what amounts to oppression of one and what amounts to mismanagement would give rise for the shareholders to take action. So, under that section 224, the shareholders in a situation of oppression could file a case seeking the intervention of the court and provide relief in such circumstance towards the shareholders. Also, in a case of a mismanagement, they can come in the same way to the court seeking remedies. Now, generally, in any situation of like manner, the shareholders tend to come using both these sections 224 and 225, alleging that there has been acts of oppressive acts of oppression as well as mismanagement coupled together and committed by either a director or directors of the company. So, in such case, the court, the shareholders, this is a shareholder action where the shareholders can take action against the director board. The shareholders can seek preventive measures of recurring oppression and mismanagement in the company by asking for an interim relief from the court to hold the affairs of the company in a kind of a relief being given as an injunction to prevent these directors from acting as directors of the company until the final determination of this action. There, the court, after going through the merits of the matter, can grant an interim relief to the shareholders, preventing these directors or director acting in this detrimental manner of oppression or mismanagement. And thereafter the court can continue with hearing of the case to finally determine whether these respondents are responsible or not for the alleged oppression or mismanagement. So, interim wise at the beginning, the court can give an interim relief such as first of all interim relief to prevent at initial stage the directors from continuing office. Thereafter can give temporary or permanent injunctions preventing these directors from acting in the company in this capacity, and pronounce that they have really committed acts of oppression or acts of mismanagement. So, we will end today's discussion, and tomorrow I would like to discuss about the derivative actions under the company's law, as well as the procedures of winding up and the final closure of the companies. Thank you very much for listening, and see you in the next session of my lectures. Thank you very much.